respected Honorable Justice Shyam Prasad sir, and my dear participants. So we are going to start with the first technical session of the day. Before starting the technical session, I take this opportunity to introduce Honorable Justice B.M. Shyam Prasad. Honorable Mr. Justice B.M. Shyam Prasad, His Lordship, born in the year 1971 and in the year 1991 obtained his bachelor's degree in arts, and in the year 1994 obtained his bachelor's of law degree from SJRC Law College, Bengaluru. Sir has a professional experience from 1991 to 94. He worked under Sri Chinnappa K. Kambayanda while pursuing graduation in law, while pursuing graduation in SJRC Law College, and in the year from 1994 to 1998, he served as a junior colleague of Mr. B.N. Dayanand. From 1997 onwards, Sir started his independent practice under the banner Messrs. B.M. Shyam Prasad and Associates, Advocates and Consultants, Bengaluru. Sir was designated as a senior advocate in the year 2014. Sir was appointed as an additional judge of High Court of Karnataka in the year 2018 and permanent judge of the Karnataka High Court in the year 2020. With this brief introduction, I present Honorable Mr. Justice to the august gathering and extend a warm welcome. And I request Ms. Soumya to present a bouquet to Honorable Justice B.M. Shyam Prasad sir and extend a warm welcome. Welcome you, sir. Tanmay, is it right? Sir. Yes.
Good afternoon, everyone. The session had to begin at 12 o'clock and it's 1:30 now. I thought I'll talk to you people for about 15 minutes and then take questions for whatever time that the organizers would allot. Now that we are a little delayed, can I suggest this? You shoot questions. If I can field them well, so be it. So you would like to start with questions? Start with questions? Yes, madam.
And I decided to pursue LLB. I'm in second year of fourth semester LLB, and however my near dear ones, everyone is suggesting me that I am doing a very wrong. I have taken a very wrong decision, but I was not happy with the. Though I am getting a good package, everything was there, but I was not happy from inside. I felt like something I need to do with as a main kind service. So choosing this path is what you will suggest to me, and how my career trajectory will be in future, considering the age and the promotions are depending upon the age seniority, not on merit.
All right. Before I answer the question, can I know what was the push for you to give up what you were doing and take up law? What was the push? There must be that final push.
I came across with one poor woman who is facing very minute issues of law like PAN, Aadhaar and all those, and she is not able to get a pension, and she is suffering because of that, because of some mismatch and all. And I have seen lot of issues and the departmental problems, and she died,
so
and she has not recovered that pension.
You want to do something for people of that?
Yes.
Good. Madam has spent 10 years in another career, has taken on her family members and chosen law. Of course, she has the question, am I right in my decision? Would my decision be proved right by the trajectory that my career will take? Ladies and gentlemen, let me tell you this. As I was climbing up the stairs, I was telling our good friend, when I decided and I told my family members that I wanted to pursue a career in law, my family members were not very happy. They thought I was being foolhardy. Brother is an engineer, sister is in the medical profession. Or what is he doing? Well, my marks were not great either. So what is that makes us that choose this profession? Before I answer the question, just to see whether we are on the same wavelength, I am called, my generation is called Generation X. I am born 1971 as it was told. You are all Generation Z. You are called Zoomers. Perhaps some of you are also millennials. And after you will be the generation which is going to be called Generation Alpha, the better generation. And we all accept there will be generation difference. Generation difference. But see the commonality here. Madam chose to come this path, of course after 10 years, and even before I could think of anything else, there was opposition from the family. But something pushed us. Something inspired us. Now, inspiration, that push could come from different quarters. It could be from the people that you meet, maybe people like Lordship Justice Oak. The ease with which he can connect with people. The family members, the difficulties of somebody, and the notion that we can help somebody in need. These are good reasons. And believe me, every reason that brings you into this profession is a good reason. Even if it is making money, jolly well, it's a good reason. Why not? Why should we not? It's a good reason. Now, our context is opportunities, judicial service, challenges, judicial service. Madam, if you choose now, it's never polite to ask a lady her age, and so I will not. Assuming you complete your course over the next 1.5 years, because you said you're in 2 years, and I'm assuming it is 3-year course. In the next 1.5 years, you can take up judiciary exams immediately thereafter, which means another 2 years down the line, you are a judge if you pass the exams. And from whatever you told me, I can safely say you will have a career of 2.5 decades. 2.5 decades. So there will be, you start off at the entry level. Now, if you want to get into the district judiciary cadre, you will have to practice for 7 years. And then you will have to cross 35 age mark. Then you will have another 2.5 decades. If you start off as civil judge, J1 as it will be called from now on, you will have a career progression at the end of 10 years in terms of financial benefits. Every year there will be a increment, so the financial package is there. There is career progression because you get a next promotion, not in the same cadre, but not in another cadre, but in the same cadre into another level. Then you get to be civil judge senior division. The difference between civil judge junior division, we don't call them any longer junior division, we call civil judge, and senior civil judge is, we handle the same set of matters, but depends on pecuniary jurisdiction. If the claim is below 1 lakh, 5 lakhs now, 5 lakhs it will go before the civil judge. If the claim is above 5 lakhs, any amount, it goes before the civil judge senior division. Now that's the second level of promotion, and if you do well, remember a point was made. After 10 years, subject to crossing the age of 35 or 45 and completing 5 years, not 10 years, you get access to accelerated promotion to the post of district judge directly. So to break it down, you begin perhaps with all our wishes and luck. 2 years you will start off as a civil judge, then 10 years there will be career progression, then you get promoted to Civil Judge Senior Division. In Civil Judge Senior Division, provided you complete 5 years, you can get access accelerated promotion to District Judicial as District Judge, and then that's another, it opens other gates. Now this is in terms of career progression. Now before I take another question, I'll ask you this. 30 years back I was there. I had a few notions about what a good employment should be, what a good job should be. Now I'm testing this notion. As the notion changed is what I would like to know. Could somebody from amongst you tell me the first thing that comes to your mind on what a good job is? First thing that comes to your mind on what a good job should be. Satisfaction and stability. Now satisfaction, is it financial or job satisfaction as a larger concept? Both. What is stability? Sorry, jobs, one is satisfaction, which is financial, and the overall satisfaction. What is stability? What do you mean by stability? Madam, somebody here said stability. What do you mean by stability? Is it financial stability alone? Hire and fire, not the threat of pink slips that people in the other sector fear, correct? Oh, both are in good measure. You heard the earlier speakers say that we have National Judicial when heavyweights come, there will be some disturbance. He's a good brother. We have spoken about the salary. Entry level is minus taxes 95 to a lakh of rupees. Entry level. Madam, the moment you get into judiciary, you're looking at a pay package. Just not about C2C. Now all the software companies and the other sectors speak of C2C, cost to company. We are not speaking about C2C. We are speaking about your credit into your salary account. It's a lakh and five. And apart from that, you get other perks and perquisites like rent-free accommodation wherever you go, then your vehicle benefits, of course, home assistance. You get all these assistance. Now that is good financial stability to begin with. And on the threat of pink slips, benching, be assured, sir, madam, you perform, you don't have to fear the threat of the pink slip. When you get in, there is what is called as 2 years of probation. One has to complete that probationary period where you are evaluated, where if you are found suitable over those 2 years, there is confirmation of service. If the service is confirmed, you retire only at the age of 60 years. 60 years. And during this time, for multiple reasons that I will mention, you will not be removed from service for whatever reason without due process. You will be removed. In other words, you can only be removed if there are complaints, if you are found guilty of what we call misconduct. And after due process, it's just not that somebody doesn't like you, we say you're not a good performer and then give you the pink slip with 3 months notice. It's not like that. There's a complete due process. So if this does not mean stability, what does? And in fact, let me ask you this question. This was a big thing in my times. Getting government job was a big thing in my times. Is it still so? And that is only because of job security or stability, as somebody put it. Correct? Now, any other question? Yes, madam. Please go ahead. Sit down, please. Good question, good question. A civil judge will have to necessarily work under a district judge. A district judge will have to work under the High Court. High Court will have to work under the Supreme Court. Or does it in any manner hamper independence? That's the question. I will answer the question like this. Number of surveys are held regularly across sectors, from an employer's perspective, from an employee's perspective, as to what makes a good job. What are the markers for a good employment, good job? And in fact, one of the markers that people speak about, common to all kinds of surveys, is roles and responsibilities. There must be clearly defined roles and responsibilities. Imagine this. You are given the task of organizing an event, and you are given a team of say 9, 10, 12, whatever that number is. Now, can all of us be masters? All of us saying what each one should do? Can we reach anywhere if we run either and thither? They must be focused, right? They must be disciplined, right? So, when you speak of a judicial officer being subject to administrative jurisdiction by the district judge or by the other unit head, as it could be, you're only speaking of the requirement of any job. Most men, in fact, in my times, I don't know how it would be in these times, people said advocacy versus judgeship. Oh, there is independence and I want to be a lawyer. Oh, you don't have that independence if you're a judge. My answer is, if your purpose is to deliver as a judge, you are part of an institution. As part of an institution which has a focus, which will have to have an object, there will be certain hierarchy, but then defined hierarchy, defined responsibilities, defined safeguards. Remember, you are all protected. The moment you enter into service, you are protected by service rules. They define. You are entitled for leave. You are entitled for leave. The unit officer will decide, depending on the workload, whether you should take, depending on your need, whether you should be given. It is not refused. I would request all of you to be open-ended, open-minded when you entertain these thoughts. It's a requirement of the institution, as in every other institution. 2, it is not undefined. These are defined, and defined not as a matter of protocol, which does not have the rule of law. It is defined as a matter of rule. Rules protect you. And it's more the fear than anything else. Any other question? Yes, sir. Shoot. We'll see whether we can hear you.
Good afternoon, sir. Myself,
afternoon.
K. Nagavamsi from Keli Society's Law College. My question is, as earlier judges has mentioned that free access to justice, I want to know what does the term justice exactly means. Is it a interpretation of laws, or is it like making satisfaction of two parties?
I love these kind of questions because they allow me to ask questions. You are in which year?
4th year, sir.
4th year. You've done your jurisprudence?
Yes, sir.
As badly as I. It appears so. I'm sure your jurisprudence teacher is not here. Sir, madam is here. I will request her to take you back once again into the classroom. I would like to come back and talk to you about what justice is on another day. But to engage, sir, on that question today, in any detail would be a digression from the topic. But let me say this. What is justice is not a straitjacket formula answer, because no person's circumstance is the same. My situation is different, your situation is different. Yes, we all go by the thumb rule, which is best captured in this adage. What applies to the goose applies to the gander. Correct? That's equality. So justice is a concept which we will keep learning until the very end. And remember, sir, once a student of law is always a student of law. But if you want your answer from an academic perspective, please go back to the classroom. If you want an answer as part of this, part of a conference like this, we'll come back another day. Any other question? Yes, madam.
More than 60, 35. So why is this age notion? Even though this is my 8th year of practice in trial courts, so but still age is what matters.
Good question. You aspire to be a district judge, not a civil judge.
No,
now 35 is not in the rule book. What the rule book says is, if you complete 7 years of practice and you clear the qualifying exams and the subsequent interview, you should be eligible. And I can give you the example of Justice Manjula Chellur, who retired as Calcutta Chief Justice, who retired as Chief Justice of Maharashtra, but also was Chief Justice of Kerala and Kolkata, who was appointed as district judge at the age of 32 years. Correct? Now, if certain age is used as a factor to decide on the candidature, it has got more to do with the suitability. It is not as a disqualifier. Now, I would ask myself this question if I were ever on the committee of selection. If the talent is huge, if the merit so justifies, why should it be? So, don't see that as a barrier. If you're below the mark, or age mark that is, please make your best effort. And you've got illustrious people whom you can always cite. So if some member of the bar is ingraining that into your head, maybe he's holding you back, not pushing you as he should be. Age 35 is not a restraint, madam.
Thank you.
Any other question? Yes, madam. There was some possibility, but that is why if you go to the next cadre of civil judge senior division, on completion of 5 years, subject to age bar of the age limit of 35, you get to compete for the 10% of the total strength in the district judge cadre, which is notified on a regular basis. I'll give you a perspective. I am your junior today. You're my senior in the judiciary. You have put in 10 years. I have put in 7 years. It so happens that circumstances when exams are notified, you had certain constraint and I did not have certain constraint. Now I succeed in the exam and I come and sit over you as your senior. How comfortable would you be? How comfortable would you be? Would you be very comfortable? So you have the answer. This is one part of the answer. But remember, this is not just to judicial service. This is to every employment, except in the corporate sector, and I dare say this, where you can quit company A, go to company B, come back to company A and occupy perhaps a higher position. Now, this in itself throws different challenges. And in institution like judiciary, where certain consistency, stability, to borrow the phrase, certain satisfaction, again to borrow the phrase, are to be assured, this kind of rule serves its purpose well. Look, again, the challenge in life is to reach that balance. You can't go to the two extremes, can you? You can't. Is there life, good life in polar areas, North Pole, South Pole? Where is good life? In equator? So the balance, you must always look to the balance. Now, in bringing this rule, while not giving possibility for that, a balance is achieved. And this is not going to be, I'm not going to say it's going to be like this for now and forever. Who knows, with you people coming in, calling the shots, there could be, the society is better suited to take that rule. But today, I see a justification for that, for the reasons that I have spoken. Any other question? Yes, madam. Madam, your question has two parts. Well, please sit down. Your question has, I understand your question as in two parts. One, well, why should we decide when in college whether to be part of judiciary or not? And second part is, what if I choose international law as my subject? Then what is my career? Now, this brings us to a question which has been engaging most of us. In fact, I and my brother, Justice Suraj, we have been speaking about it for the last two days because we know we will come here and take questions. When is the right time to decide what I want to be? Now, Justice Oak was saying, in his days, the popular thought was, Ellu saldero il bartare. No persons who can't fit anywhere else come into law. Correct? So at that point of time, mind is not made out. I am assuming that this situation has changed. Now people who really want to be in law profession choose to come to law colleges. I can give you this as an anecdotal information. I was part of a strength of 235 in the class. And I may not be very wrong in saying I must have been one of a very small group who were certain that they wanted to be lawyers. The question that we have been engaging is, when do we tell the youngsters to take the decision, not to be part of the profession as lawyers, but to take the decision and work on being judicial officers? For me, personally, as early as possible. I'll tell you why. Today, you pass out at the age of 21, 22 from the law college, and you can become a judge by the time you are 23 if the notifications are timely issued, coinciding. Look at the career. You have a career span extending up to 60 years if it's district judiciary. You reach, most of us, many of them reach the High Court, which is 62, and then Supreme Court is of course 65. Today, if my information is correct, and I think so, I think it's correct, there amongst the High Court judges, the avenue is like this: 66% for the bar members and 33, whatever that decimal difference, 33, 34 is for members from the district judiciary. You start off early. You start off at the age of 24. Now by the time you're 55, you have qualified yourself for a calling to the bench as the constitutional bench. Now I'll ask myself, why should it not be at the earliest? Why should it not be at the earliest? In fact, 5 of our colleague judges from the district judiciary were sworn in the last week as judges. And my father, I mean, I'm second generation, don't hold it against me, I'll give you the reason later. Now, my father started off in the 1960s as a judicial officer, and he retired as a High Court judge. And he completed his law when the law course, as Justice Oak was saying, was only 2 years. So if you begin early, no, your career trajectory is that much better. So don't put off the decision. Don't put off the decision. If you can, take the decision early. And in fact, our endeavor would be to reach out to the institutions and say, now please bring as an elective within the curriculum on those subjects, those material that would help the students take this decision at the earliest, not after, during the course. If an elective could be introduced, and if the students are exposed to the areas that needs to be they need to be exposed, then maybe a decision is taken at the earliest and for a better career. Now, to go to the second part of the question, what if I take up interest in international law? Now, what are the career options? Wish I had the bandwidth to answer this question with all its ramifications. But let me tell you this. We are in a global village is an old expression, right? It's, I mean, I heard it 20 years back. It is no longer in coinage because it's a reality. Now, if you focus on international law, the opportunities could be elsewhere, but not here. Not here. It may not help you. It could be elsewhere. But I must confess, I may not be fully equipped today at least to say what are the career options if one were to choose international law as one's interest. Yes, sir, go ahead.
Good afternoon, Your Lordship.
Good afternoon.
My question is, from your perspective, what makes a good judge a great judge?
What is the transition? What makes the transition from a good judge to a great judge? Should we not ask what makes a good judge first, then speak of the transition?
Okay, Your
First, let us be good judges, and then we will make the transition to be the great judges.
I firmly believe that all the judges are good, but what makes them to
well,
be
you'll have a good career in profession.
Thank
It's
you, Your
always nice to compliment people. All of us are vain at some level.
Thank you, Your Lordship.
Yes. Now, that's a good question. Apart from the lighter side, it's a good question. It speaks about a very important ingredient or a marker of a good job. Now, when we say this is a good job, it is purely from one's own perspective, isn't it? Again, what is good to you may not be good to me because of our different circumstances. Correct? So, one of the markers of a good job is one's own suitability to the job. One's own suitability to the job. How suitable are you to the job? To know how suitable you are to the job, you know what the job's requirements are. Correct? Now, Madam said she took a big decision to give up practice or employment in another sector to come to the law. And the final push came because she faced the predicament or saw the predicament of a particular person. Now, this is the reason. What makes a judge? Then we'll see a good judge. Let us count on our fingers. I mean, I can only count on my fingers. There could be many more. Knowledge of law. All of us agree. One needs to have a very strong founding in the law. What else? Second, what do you expect of a judge? Well, the same aspect. Knowledge of law and the application of law, same aspect. Then, higher ethical standards. Now, let us narrow it down a little. Higher ethical standard could be anything and everything. Correct? Now let us bring it down. Let us bring it down. Focus it. Would I be wrong if I were to say when I focus so, it is the ability to be fair and reasonable? If I have to be fair, I have to maintain strong ethical standards. If I have to be reasonable, the same thing applies. So for a judge, it is very important to be fair, to be reasonable. Apart from knowledge of law. Then the third one. Application of mind. You analyze application of mind. Again, I'll put it on the first category. The other one? Good listener. Wish somebody had told me earlier. Absolutely, one has to be a good listener. I'll digress and make a point there later. Then, surprised that you have not heard of, if you have not heard of this phrase. Justice must be tempered with mercy. Correct? You know the law. You're fair, you're reasonable. But then you can't be a butcher, can you? You need to have that compassion quality in you to feel. A woman comes, a child comes, an aged person comes. There are a number of situations in every court in each day where parents are neglected by well-to-do children. You need to have the compassion to deal. Now, if we are speaking of what makes a good judge, sir, in my understanding, knowledge of law, yes, ability to be fair and reasonable, and of course the compassion. We must be compassionate, but not allow that to prevail. You must know where to rein in which quality and allow which quality to run. Now, if these are qualities, now in fact, go on the Google, you will find number of things that are spoken about what makes a good judge. Now on the question, what makes a great judge? Sir, I would like to sit there and ask this question to somebody else. I am still looking for the lesson there. And one day I'll hope to sit there and ask this question. Now I said I'll make good listening ability. I must give you this anecdote. It's written about in Supreme Court Watches, a book. In the days, very early days of Supreme Court of the US, no pleadings. When you take part in moot courts, you file memorials, right? No pleadings, no memorials. The lawyers held forth before the court. And they held forth until people dozed off. And if they were good orators, and they were phenomenal orators, I am told, I have read, that it became a social event. The high society ladies would dress up in their best, take the front seats, and listen to lawyers' oration, their presentation. So it became so much that it would go on, and it became a theater, and the judge never stopped listening and never decided. So the Supreme Court said, no, we will limit your time to 1 day. Then a lawyer could argue for 1 whole day. The next lawyer would take over the next day. Then they said, this is also not working. Then they said, 30 minutes each. Today I am told, and this was said, this book has come out somewhere in early 2020 decade. It had reached a stage where a lawyer has a battery of people assisting him to field questions from the judges. There are 9 judges. They ask questions. the team's job is to anticipate what are the questions that a judge would ask given the circumstance of the case, and prepare the lawyer to take the question, because if he opens the door, gets a foothold in that limited time, he can argue the case, not otherwise. So we have moved a little from focusing on listening to asking questions to understand what the problem is, because each one come with a different ability level. You may make a point within 5 minutes, I may need half an hour, but then we need to work towards what is acceptable. Next question, sir, remember to ask great judge, what makes a great judge, and come back. Yes, sir.
Good afternoon, sir.
Good. So we'll come back to you. Yes.
Sir, my question is, there is a notion in every people that judges won't have the personal life. They need to have the personal life, keep it aside. So what is the challenge regarding?
Yes. In fact, this has become a topic for discussion across the sector, and it is called work-life balance. You need to work, you need to have a life, weekend life. Weekend life as a connotation, fun time. So this has become a topic for conversation. And in fact, there's surveys saying that people prefer work-life balance over salary, over stability. And this, they say, has gained ascendancy after the onset of COVID-19. So people have started feeling that it is just not work any longer, it must be some life also. Now, I don't like the expression life in this context, because work is no life is a suggestion there. I would say fun life. Now, does not a judge's job allow him any fun life? Now again, fun is a difficult expression, so we'll take the common denominator meaning. I've been a judge for 4.5 years now, and I was a lawyer for about 2.5 decades before that, and I functioned as a designated senior lawyer for about 4 or 5 years before that, before my elevation. And I must tell you what my young nephew told his parents one day. He said, I want to do law, but I don't want to end up being like him. And he is one amongst you now. Now, this is true of a lawyer's life as well. And this is true of every person who is a success in his or her chosen profession. You will have to manage the work-life balance. I get my time, my family complains, does not complain, it happens both ways. And I love to play sports. Yeah, my knees crank, but still love. My work gives me that time. Not as much perhaps, but yes, it does give me time. And I see my brother have his fun without me and with me when we are on the same campus. It is all up to us how we define the balance between work and life. Does our job allow us? Yes, sir, it does allow. Now, in fact, a point was made. There's a lot of criticism of the judiciary around this point. There are to children, to judges, there is vacation. There is one vacation in summer, there is one vacation in winter. Okay? Now look at it this way. If the life during the remaining period is very time occupying, doesn't give us time, then these small windows give us that break to spend time with family, to equip ourselves, to do whatever we like. ಕನ್ನಡದಲ್ಲಿ ಒಂದು ಮಾತಿದೆ, ಏನು ಹೇಳ್ತಾರೆ, ಪ್ರಪಂಚ ತಿಳ್ಕೋಬೇಕಾದ್ರೆ ಕೋಶ ಓದಬೇಕು, ಅದಕ್ಕೆ ಟೈಮ್ ಇರಬೇಕಲ್ವಾ, ಅದಕ್ಕೆ ರಜಾ ಬೇಕಲ್ವಾ, ಆ ರಜಾ ನಿಮಗಿದೆ, But again, let me tell you, correct the, if there is any misconception. It's not a vacation. It is not as if the 4 weeks we are not working, we are not sitting. Every year, 1/3 of the judges get transferred, which means relocation. Now, if they are hearing the case till the last day and they have to sit in another place the next day, then there will only be havoc. So they need the location time for them to locate themselves, their family, their children. That is why we take this 3 months, 4 months. They are pending work to be sorted out before we go to the next session. So if you are asking me from a very personal experience, and I can also say this, it's a second generation experience. I never thought my father never gave me time. In fact, he gave me more time. He monitored me much more than I wanted to be monitored at that time. So from the family perspective, I can say this. It does allow time. From the judge perspective, I can tell you, it allows the time. It all depends on how we manage the time. So if somebody is thinking that, look, as a judge, I will have no time, and therefore I will not be a judge, I will say, look, sir, look, ma'am, are you giving an excuse? Are you looking for an excuse? It's not a good excuse if that is the case. Then any other questions, sir? You wanted to ask something? Good question, good question. What are the challenges that I face as a judge compared to my days as a lawyer? Now, some kind of an analogy was spoken by His Lordship Justice Oak. In fact, his statement, please now, his statement made me start thinking. Sir was of the view that judgeship gives more satisfaction. More satisfaction. Well, to dissent is a judge's prerogative. Maybe I could dissent with Sir on that score. For me, if I enjoyed my days as a lawyer, I do enjoy my days as a judge. Each brings its own fun. But there is certain challenges or certain changes that we have to make when we transition. A judge is expected to sit in the open court from 11 o'clock to 5:30. If it's in the High Court, it is from 10:30 to 4:45 with a break of 1 hour in the lunch, for the lunch. Now, when you criticize me for being a little rude at 4:45, think about me. From having sat from 10:30 till 4:45, and think about all the listening that I have done, and don't tell me that I will have listened only to sense from 10:30 to 10:45. Some nonsense will also have come my way, right? And I will have to listen to that also with the same poise, the same temperament. This is the challenge. You have to be seated from 11 o'clock till 5:30 or whatever that time frame is. That's a challenge. How many of you have enjoyed non-stop classes? Say 10 o'clock till 1:30. No, you can't do anything about it. You'll have to go through it. But none of us liked it, right? Your teachers did not like, I did not like, you will not like, and the generation alpha will also not like. But we have to do that, and we will do it. We enjoy doing it. That's challenge number one. Second, no, justice should not only be done, but seem to be done is one of the fundamentals. You can't be a judge in your own cause. You must be a judge without bias is one fundamental. The other fundamental is justice should not only be done, but seen to be done. Correct? Now, this pushes many requirements, changes that we have to make. That is, you can't have a large friend pool outside your own community. That's the judges' community. How would you feel about a judge, or what confidence would you have in a judge whom you see with different set of friends on each evening? Would you feel very confident? Because we could be open to influence. I may say I'm not influenced. I will never be influenced. But then what is your perception? The law, the requirement in law is justice should not only be done, but seen to be done. Now it is in this context I take the question somebody asked on social media. Correct? Now this is another change that we will have to make. I was once very active on Facebook, but I'm no longer there. Do I miss anything? Oh, I get enough tits and bits here and there. So I don't miss that at all. But then social media is also bar and bench, live law. That's also social media. We have our own judges groups where we exchange ideas. Just as Sanjeevan Chate has posted in our group the details of this occasion. Most of us know what is happening. So there are changes that we make. There's no handbook as such given to us, but when we get into the academies, we are spoken, we are told about this, so we make those changes. And those are not life-threatening changes. They are life-changing, but they are not life-threatening changes. Any other question? Yes, madam.
It's a saying, sir.
Absolutely wonderful question. I would take this question every day of my life without any hesitation. I took this question as a lawyer, and I will take this question as a judge. Every client who came to me said, "Sir, how do I trust your system? It's going to take so much of time. I present a litigation now. Maybe I will not leave property to my son or daughter, but I'll definitely leave the litigation as a legacy. So why should I give you fees? Why should I pay you fees to leave a legacy which is going to make my children again pay fees to your son or daughter?" I have faced that question. And my answer has always been this. I don't know how convincing, but I believe it was rather convincing because my clients still paid me fees. That is, I'm an interface. As a lawyer, I interface between a system and a problem. I don't solve the problem. I take the problem as an interface, as a medium, as an agency to the system. And the system with all its difficulties, I will stand by you to see that it gives you some solution. Now, this is the most forthright of answer because it defines my role as a lawyer. It defines the expectation of the client. It makes him or her take an educated decision on whether to approach the court. Now, this is not to accept the situation as a fait accompli. Now, this is where we come as judges. What can we do? Now, amongst many other things that may have pushed me, that may have encouraged me to take judiciary, is to see whether I can do something here. Now, why this problem of pendency? Courtnak bandown sot, courtalgi get down sota satta. Why? Think about it. Think about the population and the judge ratio. Think about that. Think about this. We are a welfare state. If your dog barks too much in the night, your neighbor can sue you. He can. Avanu buddhi kalistintalu court karkondogi. This is something that you will hear and you will make money out of it. Okay? Now, 2 reasons. 3, there are certain procedural safeguards which take time. But then the solution is where as lawyers we become responsible and do not take every and sundry case to the court and occupy judicial time. don't be surprised. Don't be surprised, and I speak from experience. Don't be surprised if the same dispute is presented to the court because there is no no cost barrier. COST, my pronunciation could be a little difficult. Cost barrier. The same litigation is presented thrice, and we handle it. Are we guilty as lawyers in presenting the same litigation thrice? Would you want to do it? When you call the system a laggard, which it is sometimes, please ask yourself, how much are you contributing? If I were to ask myself this question as a lawyer, and if I were to ask this question myself as a litigant, and if I respect the judicial time and the constraints and the strain on the judicial time, maybe we have done a wee bit to reduce the time span that a litigation takes. And that, ladies and gentlemen, I beseech each one of you to do. Do not bring a frivolous litigation to the court. Because a frivolous litigation does not do anything for your client except wreak vengeance, but takes away time for the judicial time that is required for the needy. Time for the needy. And remember why people are speaking about the time that litigation takes. Now, I'm not speaking about to you as general public. I'm speaking to you as members of law field. It's our responsibility. And remember, one of the markers to say you're a good economy is how quick your disputes are resolved. So don't ask me this question, is what I would tell any lawyer. I would ask the lawyer, you ask this question yourself, how many frivolous litigation do you contribute to, which sits on the judicial time? We must ask ourselves this question. I'll ask every litigant who comes and complains to me that my system is a laggard system, it is lagging, it takes time, it kills people's patience. I'll ask this to every such litigant who thinks he can take advantage of a system which is overly burdened. Madam, this is my answer to the question. My answer to the question as a request. Please, possible, wherever, tell people that it's a overburdened system and you will take only such cause as is required. These are matters of balances. When you are practicing, Madam will tell you there, when you have a monthly bill to pay at the end of the month and a client comes to you, you're not seeing whether it is a frivolous litigation or not. You're thinking of your bill. So these are all challenges, professional challenges that we need to handle. And should there be a systemic change in this? Yes, all of us are aware of it. It requires changes in terms of infrastructure, not just in terms of court halls and judges, but also in terms of the technology that we bring in to identify measures that could speed up many disposals. Next question. I can be passionate about this. Yes.
I beg your pardon.
Oh, I have run my time?
Yes, sir. We can resolve the questions for the second session of Justice
Before that, yes. Sir, you have asked too many questions as a judge when I was a lawyer.
My lord, this is only in addition to the question asked by Madam.
Yes.
Regarding why the civil judges are not permitted to take direct district judge examination.
Yes, sir.
This is a question being posed for several years. I was a part of district judiciary as a judicial district judge and also principal district judge. I was a principal district judge and I was president of the Judicial Officers Association, State Judicial Officers. And there was an occasion for me to go to South India Zonal Conference of the state associations, and many young officers, judicial officers, we have put more than 10 or 12 years, up to 10 or 12 years service as judicial officer in civil judge, not senior civil judge. They are asking me questions. Why, sir, we are not permitted to write a DJ examination directly? Why only the advocates, and recently the trend is emerged permitting everywhere. I'm sorry, due to my ill health for 7 months, I am not able to speak properly.
Sir, you are more clear than I can ever be, sir.
Yes, sir. And now recently, the assistant public prosecutors, those who are government bidders at civil judge courts, are permitted to write DJ examination. The question is, when everyone are government servant, not advocates, but they are pleaders on behalf of the state, appointed by state, but they are permitted to take examination. Why civil judge junior division, civil judge are not permitted? So now the matter is put at rest by the Honorable Supreme Court, and during that pendency in the Honorable Supreme Court, one of the candidates from Karnataka went up to Supreme Court, and subject to condition result of the Supreme Court, they are permitted to write examination. That's all. And ultimately, what the Supreme Court delivered is, civil judges are not permitted, are not allowed to write DJ examination directly. Now that is the matter. But my question is, my concern is, in order to make judicial service one of the lucrative career, because we are thinking about the salary, perks, whatever may be, that comes automatically in natural way. But somebody are thinking on their career prospects also. The MBBS are allowed. Why CJs are not allowed? Because there is no scope in the constitution, in the amendment, in the articles for recorded district judges, and the rules. Your lordships told the only the advocates who have put not less than 7 practice, they are permitted, and the same applicable to MBB also. So why should not be allowed to civil judges to take exam? Because as a principal district judge, I am authority to make some remarks on CR. I have seen the young and talented advocates, those who have practiced only 1 or 2 years, got selected civil judge, or those who have not practiced, and young lawyers appointed civil judge, they write judgments very well, with reasonings, with all mental aptitude regarding applying their skills in law. But at the same time, the experienced district judge are committing mistakes. Even they do not know the basics of how to pass sentence. For example, in the 302 cases, it is dealt by district only, awarding 14-year, 20-year punishment, not allowable.
So can I respond like this?
That's why, my lord, Hon'ble, it is one debatable question. Why there should not be amendment to the constitution and the rules, making the civil judge to write DJ examination also. Like ABUs are selecting, recruited recent for some recent years, your lordship is a part of committee, some ABUs are. Your answer is correct, because one junior civil judge will become a district judge, or taking other seniors. The same applicable in ABB also. The ABB were practicing before the civil judge, later on will become a district judge.
Can I just
That's why a debatable question. Why my humble request is, why there should not be amendment to the concerned articles and rules. That's only because
no, I'll just recollect
to be
what.
made judicial service as more lucrative.
No, I'll recollect what was my answer to Madam's question. One, it is to sir, it is perhaps in the interest of discipline. One. Second, I said things as they stand now are this, but the generations to come can always change. One thing is certain, sir, as students of law, nothing is static. Society is not static. The law, which should not be reactive, but even if it is reactive, can never be static. If the need of the hour, as it is then felt, is that there must be this change, then that change must happen, sir. There's no doubt about it. But the thought that I put out is there a discomfort issue? Please think about it. Now, it's been wonderful spending an hour talking, knowing the younger minds. It's been 30 years, 35 years away from campus. So wonderful coming back, connecting with all of you. And I'm sure you will be as merciless with my brother Justice Suraj as you were with me. Thank you.
I profusely express my gratitude to Honorable Mr. Justice P.M. Shyam Prasad sir for sparing his valuable time to address the aspiring students who wish to join judicial services and addressing all their queries and encouraging them to join the judicial services. I once again thank and I request Dr. Bhakti to present a memento as a mark of respect to Honorable Justice Mr. Shyam Prasad. Thank you, sir.